In today's video, we're going to be talking about the penalties for battery-related crimes, continuing on with our series. My name is Adam Rossen. I'm a criminal and DUI defense lawyer in South Florida. I'm a former prosecutor. We have over 400 five-star reviews between Google and Avvo, and we've had the Rossen Law Firm now for quite some time, and we help good people when bad things happen to them. We're going to start off with misdemeanor battery, which is the lowest level battery offense, simple battery or misdemeanor battery. And so that's a first-degree misdemeanor, meaning the max punishment is a year in jail, a year of probation, any combination of those two, and a $1,000 fine. That crime, as long as you get a withhold of adjudication, meaning you're not convicted of it, is a sealable offense, as long as it's not domestic violence battery, and we'll talk about domestic violence in another video series. The second battery crime that we're going to talk about is felony battery. That is a third-degree felony. The maximum punishment is 5 years in prison, 5 years probation, or any combination of those two, and a $5,000 fine. In Florida, for any felony cases that we have, there's what's called the Criminal Punishment Code score sheet. And what that does is it categorizes and classifies crimes. So felony battery is a level 6 offense, which gives it 36 points on your score sheet. Now, if you have more than 44 points, it's mandatory prison. Now, they say mandatory prison. There's plenty of ways to get around that, which I'll talk about in another video. But if it's your first offense and you get arrested for felony battery, then you're at 36 points with no prior offense points. So you're not going to be scoring mandatory prison. The highest level battery charge is called aggravated battery. Now, that's a second-degree felony in Florida. The max punishment is 15 years in prison or probation or any combination of those two, and the max fine is $10,000. Going back to the Criminal Punishment Code score sheet, or the score sheet as it's commonly called, an aggravated battery is a level 7 offense, which gives it 56 points. That's a lot of points. So what that means is if you have no prior criminal history and it's your first arrest for anything, anywhere, you're going to get 56 points. That's more than 44, which is the minimum for prison, and they do a math calculation, and that's going to put anybody, first offense, aggravated battery, looking at a minimum of 21 months in prison with a maximum of 15 years. Again, there's plenty of ways to get around the 21 months. So let's talk about that. Well, we can beat the case at trial. We can file legal motions to suppress that will help negotiate either reduce charges or negotiate around the minimum 21 months. It can be based on witness issues, legal motions, constitutional violations. We can even do what's called a downward departure or a youthful offender sentence. So a downward departure is we basically file this motion for downward departure with the judge, and we say, Judge, there's all of these statutory reasons, and we'll do a separate video on all of them, but there's all of these statutory reasons that you should depart downward from the guidelines, meaning reduce the sentence. This client doesn't deserve 21 months or whatever the prosecutors want. We're seeking probation or house arrest or whatever. And downward departures, if done well and put together with an expertly done mitigation packet, oftentimes are very successful in these cases. And so the last thing that the judge can do on an open plea for a type of downward departure motion is called a youthful offender motion. And if the defendant is under 21 at the time of the offense, we can file a motion to be sentenced as a youthful offender. And if the judge grants that, then we can get around any minimum penalties, any minimums on the score sheet for points. So that's another very powerful tool in our arsenal to get around these very serious felony charges and that have serious penalties. Now, with all three of these battery charges, prosecutors typically want extra penalties besides probation or jail And a list of what they include usually would be community service, no contact with the victim, if there's any restitution. So on the felony ones, felony battery or aggravated battery, a lot of times there's restitution, hospital bills, things of that nature that need to be paid. Sometimes the prosecutors will want substance abuse evaluation and treatment, or a psychological evaluation and treatment, or really any other counseling that they think is necessary depending on the facts of the case. And in some of our cases, it's really good for us to have our clients do that and do that early, because we can use that as part of our mitigation packet. And in other of our cases, it's not necessary, or we believe it's not necessary, so we don't go that route, and we don't want a lot of those extra stipulations. So it really just depends on the case. Another question that we get often is, well, what if the deadly weapon for an aggravated battery is a firearm, is a gun? Well, then it takes the aggravated battery into the 1020 life firearm statute. And that does a few things that really enhance the crime and make it that much more serious for us to defend. First, it enhances the second-degree felony to a first-degree felony, meaning the max punishment now is not 15 years, but it's 30 years in prison. So effectively, it doubles the maximum punishment. And there's also a 10-year mandatory minimum for using a gun. So for example, a pistol whipping somebody, you're using the gun. You're not discharging, but you're using it. And if you use, that can be considered a deadly weapon if you pistol whip somebody. And for anybody who doesn't know, pistol whipping is taking the pistol and hitting somebody with that firearm. That gives you a 10-year mandatory minimum sentence. Now, if you discharge the firearm, meaning shoot and miss, there's a 20-year mandatory minimum sentence on that. So the maximum becomes 30, and there's 20 of that is a mandatory minimum sentence. Now, it's really not likely, given this type of charge, aggravated battery, that you'd shoot and miss, right? Normally, on an aggravated battery, you're going to shoot and hit somebody. So the next type of mandatory minimum for an aggravated battery would be if you shoot and hit somebody, but you don't cause great bodily harm or major injuries. So let's just say it's a nick or a surface wound. That would fall under the 20-year mandatory minimum for the 1020 life statute. So the aggravated battery would have a 20-year mandatory minimum sentence with a max of 30. Now, if you shoot somebody and you cause great bodily harm, right? So if you shoot them and it's a serious gunshot wound, then there's a 25-year mandatory minimum for the great bodily harm with a maximum of up to life in prison. So Florida's 1020 life statute is very tough on all gun crimes, and especially with the way that it enhances or aggravates aggravated battery charges and raises them up. So I've talked a little bit about these mandatory minimum sentences, but there's really only 3 ways to get around a mandatory minimum sentence. So if you remember before, I talked about a downward departure with the judge. That is not allowed when there's a mandatory minimum. So it really takes a lot of the defenses away from good defense attorneys and puts a lot more power in the prosecutor's hands. So the first way would be a not guilty verdict at trial. The second way would be if you can convince the prosecutor to waive the mandatory minimum sentence, which sometimes they do, sometimes they don't, and again, they use that for leverage, or if you file that youthful offender sentence. So that is the one way that a judge can depart, and that's only available if you are under 21 at the time of the offense, the time of the alleged crime. You can get that. So again, no downward departure. The only way a judge can intervene is if you're under 21. And if not, then it's either up to negotiation with the prosecutors, or you got to go all the way to trial to get a not guilty verdict and get around that. And why is this so important? Well, obviously there's, the mandatory minimums are, like I said before, give the prosecutors all that power, but mandatory minimum sentences are also a day-for-day sentence. So what that means is there's no early release, there's no gain time. If you have a 10-year mandatory minimum sentence, you're serving 10 years in prison. Whereas if you get sentenced to 10 years of prison without a mandatory minimum in Florida, you're going to get gain time. You're going to serve 85% of that time and then be eligible for work release and some other things to really reduce the prison population. So that's another big problem or big hurdle that we have to overcome on these mandatory minimum sentences. Hopefully that gives you folks a greater understanding of all the different penalties that there are for misdemeanor battery, felony battery, and aggravated battery. If you have any other questions, anything we can do to help at all, just give us a call, 754-206-6200. You can always find us online at RossenLawFirm.com. We'd love to answer your questions, give more free advice, and help anybody out that has a case. And we look forward to helping you out.